Well, if Lydia was having trouble with the password, I imagine everybody else would be too.
I think so too. But yeah, I'm not seeing, oh, I have the wrong thing up, but I'm not seeing participants. I will send one more email to Lydia, but yeah, you can proceed how you want to proceed, Carolyn, your meeting.
Well, what can we do without quorum?
You can talk.
We can talk. We can't approve the minutes, right?
Correct. You can't
We
vote
could-
on anything. So typically in the past, when we have not had a quorum, we have not done a case review because we don't really get the part where everybody weighs in. With Rick's comments, we would have 1, 2, 3, 4. So that is a quorum, but it's really not the level of discussion that we like to have. So typically we do the training and stop.
Oh, here's Jose.
There we go. Now we got a quorum.
Okay. That's good. But we're still missing our new members, right? Well, no, Rick. Rick is a new member. So we're missing Clay. Clay and Monique. Okay. Now that I have wrapped my mind around what's happening tonight, why don't we get started? We can start with the agenda and materials review. The only change on the agenda that doesn't really matter is that we're approving the minutes from the July meeting, not the August meeting, because there was no August meeting. I don't think that really matters, but I thought I would say that. Does anybody else have anything to add or change with the agenda or materials or questions? Okay, so why don't we, now that I say that, why don't we change the agenda all around? I want to approve the minutes when everybody's here, more people are here. Does that make sense? Okay, so we'll put that maybe right before the break after the training topic. We'll just quickly approve or adjust the minutes. We can go into comments from board members and commission liaisons. I don't think I have any, although I'm hoping that in the auditor report later on, we get an update on the new office space and employment updates if there are any. So that's my request. I will put it in order of speakers in the chat, but let's go with Alan next for your personal comments. And then if you did the police commission, we'll hear about that too.
No personal comments. And yes, this is a rare month where the second Tuesday follows the second Thursday, which sometimes happens. But there was no police commission meeting. So there's only been one police commission meeting since I've been liaison. The Dove medical protest was a hot topic. There was a lot of talk about that. It segued into one of the other topics, which was the mutual aid policy, which kind of got tabled to get revised some more. But at the Dove protest, Springfield was called in and mutual aid, and they came in full tactical SWAT gear, and that generated some discussion and about the control of Eugene over Springfield. That implicated the auditor's office. There was discussion about what happens when a Springfield SWAT officer, misbehaves in Eugene. And it was pointed out the strict jurisdictional limits of the office of the city auditor in Eugene. The Cahoots gave a presentation, which was interesting. It was remarkable to me that it's been like 17 years or something since you could call Cahoots directly. But it was, a good report about Cahoots. And then they're close on their de-escalation policy reviews, and there was some input apparently from us, and but it got tabled and back to the drawing board. And so I would have more information, and I'm going to seek clarification about note taking from either the auditor or the city attorney's office so that I don't create a public record inadvertently. So I'm going off the agenda instead of, I didn't write down notes, but I'll learn what what I can do in that regard. And that is the police commission liaison report. Thank you.
Thank you. Hello, Clay. I'm just gonna update again. We're just going through the comments from board members. So I'm putting the order in the chat again because I don't know if you see it, but Bernadette and then Jose and then Clay will be next.
I don't have anything personal. I did have a question about calling cahoots directly. I thought they were only dispatched through EPD.
Yes, I'm saying that to me, I didn't realize that change had happened so long ago, almost 2 decades. You know, it used back in the day, you could call cahoots. You didn't have to go through the non-emergency number. And that was, I guess, a personal observation that had been a long time. There was discussion about the efficacy of that. You know, it makes sense. It's safer for the cahoots people. It's got a lot of efficiencies, but it also has a barrier to entry to cahoots because you have to call the police. So, but that was the discussions.
Oh, so you weren't saying that you can call cahoots directly. It was previously you could. I guess I only knew that you could only call through the police department. So, and they still have 2 vans paid through the police department's fund.
Yeah, I mean, they also work in Springfield, so there was, I'm not sure how, who the funding was split, but yeah, it seemed to be good coverage, and the cahoots people that spoke were very positive about the mission and the support from the city. So,
Okay, thank you.
Jose, do you have any comments? Maybe Jose is not here. Let's move on to Clay. Clay, do you have any comments? And then we can come back.
I don't have any comments except to say sorry that I'm late. Now that I'm back in the office, it's hard to get here at 5:30, but I will keep trying my hardest.
Well, hopefully our meetings will be in person someday.
Yeah, when we're in person, it'll be easier. Yeah.
Okay, I still don't see Jose popping up, so. Oh, there he is.
I am here. Sorry, running a little bit late. Kid had a birthday today, so sorry about that.
You don't need to apologize for your child having a birthday. That's exciting. Happy birthday to them. Did we have, it's been a very long time and I'm trying to remember if, I think, Jose, are you still the Human Rights Commission liaison officially, or did we pass that on to somebody else?
Officially, I don't think we passed it on, but have unsuccessfully been able to contact, get in touch with the chairs. I don't know if they switched or what happened, but yeah, never actually got, there was an email that we got in touch with back in the spring, and then yeah, wasn't able to connect with them.
Okay. So we haven't had anyone at the meetings, which is fine. That's not like a legally binding thing. So sounds like Monique is having trouble logging in. We can move on to, why don't we do a minutes approval now? And that can give Monique a little bit more time, since Monique wasn't really part of the discussion last month with her new role. Anyway, let's approve the minutes. Does anyone have anything to adjust for the July minutes from the July meeting? Okay.
I'll move that we approve the minutes.
Second.
All right, I think they're approved, or we give a thumbs up. We can do everything. Bernadette, you have your hand up.
No, I didn't mean to. I was trying to put a thumbs up. Sorry.
Got it. Okay. Okay, why don't we move on to public comment then? We have no public. Is this a problem that it's hard to get into this meeting? I assume it isn't a problem since there's the phone option to log in.
Are you saying, is it a legal problem?
Yeah.
Oh, we do have a real lawyer here. In my opinion, no, but Lauren, please weigh in if I'm wrong, because there is the phone option, but.
Well, this is a great segue into some of our public meetings discussion for later, but typically the public meetings law is a what I'm looking for. It's not a participation requirement. It's the ability to watch the meeting. So as long as folks can access it in some way, whether that's via the phone or I would argue even later via recording, then we're probably okay. Although from a transparency standpoint, it would be better if they could log in contemporaneously, but I'm sure that staff is working on that for next time.
Yes, staff is doing that right now. So sorry. Yeah, I'm trying to get Monique to call in so I can then promote her to panelist from there, but we're just, what is that thing where you're trying to solve all the problems at once? I'm gonna stop talking now. Thanks,
Okay.
Caroline.
And I'm assuming, I don't know, that the attendee is Lydia and that Lydia does not have public comment. Okay. So let's move on to the training topic. Although, wait, is this, is that Monique?
Monique, is that you?
Hello.
Hi.
It
Okay.
is.
I'm so sorry. I don't know what is going on. I'm glad we were at least able to get you on the phone. I'm going to continue to try to find ways to invite you as a panelist, but I'm going to leave you in this I don't know, access point if that works for you. Is that okay?
Sounds good. Thank you.
Okay. Thank you.
All right, Monique, this is Carolyn. We just went through comments from board members and commission liaisons. I'll give you the opportunity now. If you have any comments that you'd like to share, this would be a good time to do it.
Nope, I'll just not have any comment. Thank you.
Okay. And then we also approved the minutes from last month or 2 months ago, just to get you up to date. And we're about to start. Oh, there is no public to have public comment. And now we will have our training topic with the city attorney. And I will let somebody else introduce Lauren.
I think that's my cue. We are fortunate tonight to have Lauren Summers here from the city attorney's office. Lauren is, I consider her an expert in public meetings and public records law. I think that's accurate. She's been at the city attorney's office for, is it 5 years? But she's been doing municipal work for a very long time. So welcome, Lauren. I really appreciate you coming tonight to share your knowledge with us.
Thank you for that lovely introduction, Leah. Hello, everyone. As Leah said, I am Lauren Summers. I'm an assistant city attorney here with the city of Eugene. I work primarily with the planning and development department doing land use work, but also do specialize in public records and public meetings. Been with the city for 5 years, but have been practicing local government law for almost 16 now, I guess. So yeah, it's my pleasure to be with you tonight and to do this public records, public meetings overview training. Just a couple of quick initial comments. I'm sure that several of you have had this training or some iteration of this training in the past. And so if there's anything that you want to ask or chime in on, that would be great. And for those of you to whom this is a little bit new, that's fine because things like this don't exist in the non-public realm. So this training is intended not to get into kind of every detail of public records and public meetings law, but instead rather to kind of give you an overview and enough information so that if you're faced with a public records or public meetings issue, you can kind of have the red flag come up and say, I think Lauren talked about something like this in the presentation. I'm going to contact Leah, I'm going to contact Lindsay. They can contact the city attorney's office if necessary and get more information about the specifics of the issue that you're dealing with. So with that, Lindsay, if you will share the presentation. Great. Beautiful. So next slide, please. So we'll start with public records. And actually, Lindsay, if you could go back, just I think there's one previous. Oh, no, I lied. You're doing great. Okay.
Really, sorry, Lauren, I just want to make sure, especially for Monique, since she's on the phone, I can send you guys these slides after the meeting. Just so
Oh, yes. Thank you, Leah, very much. And I also sent over to Leah and Lindsay a handout that's separate that we provide to all members of city boards and commissions that talks in a little bit more detail about public records and public meetings, but also goes into government ethics issues and election law issues that may come up for you as a volunteer for a public body. And if you have questions about anything in the handout, please feel free to contact Leah or Lindsay, and they can work with our office if necessary to kind of get you more information about specific questions. So public records law, about transparency, it is kind of, Oregon has a public records law that is basically the analog to the Federal Freedom of Information Act, which some folks may be more familiar with, but it is a specific state law applicable in Oregon. And kind of bottom line, in Oregon, the public records law requires that the public get access to records and documents that are created, used, or kept by public bodies. So the thinking is that, the city is a public entity, the public, we're funded with public tax dollars, the public should have access to documents that the city creates, uses, or keeps. Next slide. So first question is, what counts as a public record? And the definition is very broad. It is, we use the term record, but you can typically think of it as a document, although there are other things that are public records too, including voicemails and videos. And so any record that contains information related to the conduct of the public's business, and then we go back to and is owned, used, or retained by the city. And I've listed a few things that can include, obviously things like agendas and public facing documents that the city creates, but also emails, photographs, reports, handwritten notes, which Alan, I think you were alluding to in some of your comments. And so, if I have a copy of an agenda that's a clean copy, and I have a copy of an agenda that I've taken handwritten notes on, those are two separate public records now, and they both need to be retained, and they're both potentially subject to disclosure. Next slide. So who has the right to inspect these records? Pretty much everyone, unless the records are exempt from disclosure, and we'll talk more about that in a minute. Generally, the identity of the requester, who they are, and why they want the record is not important. The city doesn't really get to, in most cases, take that into account. There are specific deadlines by which the city must respond to requests for records. And the city does have the ability to recoup the reasonable cost of responding to a request. So the time that it takes for staff to look for records, collect them, make copies, etc. Not all public records are available for inspection, and although most are, but there are a few, including attorney-client privilege communications, records related to litigation, personnel discipline, criminal investigatory material, that are exempt from disclosure. And some of them are kind of broadly exempt from disclosure. Attorney-client privilege is a very broad exemption. Some of the other exemptions are, you have to jump through kind of more specific hurdles to take advantage of an exemption, or they're more narrowly tailored is probably a better way to say that. As the Civilian Review Board, you will probably run into a lot more exempt public records than members of most boards and commissions. When I give this presentation in other boards and commissions, typically the answer is everything they touch is going to be disclosable. You will see quite a few more records that are exempt from disclosure by the nature of your work. And so Leah has a really good grasp on what those are and the precautions needed to talk about or handle exempt public records. So in addition to the disclosure obligations, which is what we talked about, how can people get access to public records, the city also has retention obligations. We have to hold on to them for a particular period of time so that the public can access them if they want to. There are pretty significant records retention schedules that are adopted by the state that apply to the city. And you don't need to know them, but for your purposes, what you do need to know is that the records you create, so emails that you send in your position as a civilian review board member, notes you take, etc., are public records and do need to be retained. You can't just recycle them or delete them when you think you're done with them. So the way that retention works for members of different boards and commissions kind of varies, but I would encourage you to talk with Leah and Lindsay to figure out, I don't know, Leah and Lindsay, if you already have an existing system for retention, you want to talk about that a little bit?
Do you mind if I jump in?
Yeah,
Okay.
that'd be great.
Okay. So for retention, when we're in person, it's quite easy because you hand us your little notebooks and we keep them. It's very easy. These days it's a little tougher because you are, presumably taking notes at home or taking notes on your computer or whatever you're doing as you're going through the electronic files. So what I request and what we do is if you email those to Vicky, we will retain those for you. Automatically, whatever you email Vicky is a public record. So it's sort of useful that way and that we can just hold on to it. So thank you for doing that. And then Lauren, if I really quickly go into personnel records, does that interrupt you too much or is that okay? Okay. All right. So the Lauren mentioned personnel records, which is basically what you're looking at, right? Those are the records you guys get every month. Those investigative files are personnel records into public employees. So there's actually two different sections of state law that cover those personnel records and why they can't be released. And one of them says they can't be released if there's any discipline imposed. And one of them says they can't be released if there's not any discipline imposed. So the police are very well covered as far as their personnel files not getting, being covered under different sections of exemptions to the public records law. So when we're talking about a case in public, the system we've come up with to solve this problem, to discuss personnel files in a public meeting, is to not give personal identifiers. So in our meetings, you've noticed, we have Officer A, Officer B, Supervisor A, Supervisor B. We try to avoid gender-specific pronouns. We try to avoid specific assignments of those employees, if that can narrow it down, but we want to avoid giving information that would allow that person to be identifiable based on this, that are specific to that person. And I'll stop talking now. Lauren, go.
That's great. Thank you, Leah. The last piece of retention is kind of a best practice that my office recommends, and I suspect that you do this already, but the city doesn't typically provide City of Eugene email addresses for board and commission members, but my strong recommendation is that you create a separate free Gmail email address for your CRB correspondence so that it's all in one place. And if you ever get a public records request for your correspondence, you can say truthfully that if I have anything, it will be in, it will be in this email. It will be, if I have any notes, they will be in this separate folder that I only put my CRB stuff in. So there's no need at any time for anyone to go through your personal documents to try to look for public records that may be responsive to a request. It just keeps things cleaner. It's easier for you to organize. So if you have not done that already, I would strongly recommend it. And it could just be something like Lauren Summers, Eugene CRB at Gmail, or whatever you like. Next slide, please. So that's my kind of nutshell public records presentation onto public meetings. The corollary to public records law, also about transparency. And again, similarly, it requires that decisions made by governing bodies of public bodies be arrived at openly, that the public have access to and be able to understand the decision-making by the governing bodies of public bodies. Public meetings law applies whenever there's a quorum and that quorum meets to discuss public business. The statute uses the phrase governing body of a public body, which if I were just reading that would make me think, oh, that's the city council, right? They are the governing body of the city, which is the public body. But it's actually defined much more broadly than that to include the city council, but also appointed boards and commissions of the city and even subcommittees of those appointed boards and commissions. So if there's a quorum of the CRB and you're talking about public business, then that's when your kind of antenna should be going up about whether or not you're complying with public meetings law. And I think I kind of went all over the place, but I think I got through that side. So what does public meetings law actually require? Requires notice at least 24 hours in advance, except in the case of an actual emergency. So if the downtown Eugene is flooding and the city council needs to meet to authorize a contract to stop the flooding, they could do that with less than 24 hours notice. But it has to be a real true emergency, otherwise at least 24 hours notice. And most boards and commissions of the city, like the CRB, have regular meetings that are easy to notice. And in that case, we would encourage much more than 24 hours notice. I think typically you give in the neighborhood of 7 days notice or more. Meetings generally have to be held within the jurisdiction, so within the city of Eugene. The meeting site has to be accessible, and minutes of the meeting has to be taken, or the meeting has to be recorded. And there are some new requirements that didn't make it into this presentation that kind of came out of the pandemic about making sure that there is both physical and virtual public access to meetings now, so that the public have more opportunity to be able to access meetings from wherever they are. This is what we were talking about a little bit before, that the public meetings law is a public access law, generally not a public participation law. Some members of the public don't always understand that. So it requires that members of the public be allowed to attend meetings, but generally not that they be allowed to participate in meetings, except under certain circumstances. So for example, the Planning Commission has state law requirements about public hearings for certain types of land use decisions where the public must be allowed to participate. And the Eugene Code and your own bylaws do require an opportunity for public comment at all your regular board meetings. However, that doesn't mean that the public gets to participate in other discussions that you might be having about discipline or other things. So executive sessions, again, and this is one of those places where most boards and commissions will never go into executive session, but you might. And so the public meetings law allows governing bodies to meet in executive session under specific circumstances, much like, there are only a few bases on which public records can be withheld from disclosure. There are only a few bases on which boards and commissions may meet in executive session, because the default is they should be open, meetings should be open to the public. Reasons for executive session that come up most frequently are to consider public records that are exempt from disclosure, to consult with my office regarding lawsuits that either have been filed or are likely to be filed, or to discuss performance evaluations of public employees. So those are all valid bases for executive sessions. Members of the news media are allowed by law to attend executive session, but they are prohibited from reporting on what is said. So they get to sit there and listen, but they're not supposed to say anything about what they heard. However, the be aware of the parking lot conversation is, I have previously worked with a number of small cities where folks kind of got caught in this trap where, a reporter would come up to them after an executive session in the parking lot and start talking about what happened in the executive session. Now they're out of executive session, and anything that you say to the reporter is fair game for that reporter. So the whole point of executive session is to keep that information confidential, and it shouldn't be talked about to anyone outside of executive session, even folks who were in there with you. And that's, oh, I guess I say it's the end, but I have one more thought. I had one more thought. Oh, I know what it is. So the public records and public meetings law are old, right? They were adopted in the 70s, and they don't typically take into account advances in technology, such as email or electronic chats of various types or social media platforms, where potentially a quorum of a governing body could communicate with each other about city business in close to real time. And so we don't have specific laws related to how you can use email and when that turns into a public meeting or other types of kind of chat functions. But my advice is generally, if there are a quorum of you talking back and forth and it's close to real time, you should be having red flags about whether this is actually a public meeting that the public is not able to watch or participate in because it's happening out of the public sphere. So it's okay to push information via email, but you should be very careful, and I would just say generally not respond to emails from your fellow board and commission members, and especially not reply all. And I don't know how often this would happen, but if you're all on, if you realize, oh gosh, we're all, on Facebook at the same time, or we end up in another kind of situation where there are at least 4 of us, be really careful not to talk about public business. You can have a quorum in the same place and not violate public meetings law as long as you're not talking about public business. But when you start to cross that threshold, then you're kind of in danger territory. Alan, did you have a question for me? Or
I do, thank you. I have 2, but on that particular topic, say that I'm copying the chair and the auditor and the staff. Is it just members that is the 4?
yes,
Okay,
thank you for that. Yes, it
all
is.
right. And I do have another question, and if it's a good time or I can wait, it's up to you.
It's fine with me. I guess I'm
Okay.
sorry, I should defer to the chair to be calling on people.
It's okay, Karen, okay. My question is, I think I know the answer, but so we are reviewing materials that are exempt from disclosure often. And in the process of reviewing materials, if I make a mental impression, like 1 word or 2-word note on a piece of paper about something in a report that is exempt from disclosure, it's a 2-part question. Am I creating a public record? Probably yes. Am I doing any, when I send it to, if it's confidential, it's based on, it's my impression of a record that I'm not supposed, I have pledged to keep confidential. When I send it to the staff at the auditor, I'm not, it then becomes for the city to decide whether it's exempt or not. Is that how that works? So I'm not entitled, I cannot write anything down when I conduct my review unless I am planning to retain it in a folder or send it to staff. Yes?
Yes.
Thank you.
In terms of the retention question, that's accurate. In terms
Thank you.
of, yes, whether the record that you've created is also exempt from disclosure, that would be analysis that staff would need to go through, probably in conjunction with my office if there was a request for that record. Whether it's good practice to create such records, I will leave to Leah to answer. But I understand that there is, it is you're going through a lot of information, you need help kind of remembering your impressions. I'm not saying don't create the records, but do know that it is a public record, potentially subject to disclosure, and we'll have to kind of do that analysis if a request comes in.
Yeah, I would say, so it was only within the last year or so that we've switched to doing an electronic distribution of the files. And so what, like Vicky's process, it used to be when we would give you all hard copies was go through them and find the pages with notes and hold on to them. So yeah, those are all retained somewhere in the office. Vicky knows. But yeah, I mean, it feels a little onerous, I know, but it's important. So sorry, Jose, I'll stop talking.
I'm sorry, I think Carolyn was first.
I think I have a quick question. In terms of retaining the records like that, like what Alan was asking about, we can retain it ourselves until we get it to Vicky. That's correct. Or we could retain it forever if we wanted. But you all are offering to let us have you do it for us, right?
My recommendation would be to let us hold it because you won't be on the CRB forever. And if we were to receive a public records request, we wouldn't necessarily know to contact you and ask you for those records. So my recommendation would be to let us hold on to it if that's.
Okay. So then I guess the follow-up question, or I don't know, maybe not a question, but we can, if we make a hard copy, like if you're writing with a pen and paper rather than digital, we don't have to scan that and email it in. We could actually just drop it off at the office physically. Yes. Okay. Thanks.
Hi, Lauren. Thanks for your presentation. Is body worn camera footage considered a public record? Why or why not?
It is a, going back to that slide, if I can remember, it includes images related to the public's business that is owned, used, or retained by the city. So yes, it is a public record. Some of the images on the body worn camera, in particular, officers' faces, and in particular, if there are any undercover officer faces, may need to be redacted out before that footage can be disclosed. And it is, my understanding is that it is a relatively expensive process to do some of that. So I think that can potentially be a barrier to requesters, but it is definitely allowed by, so that some of the redactions are required by state law, and then the city's recoupment of its actual expenses in responding to the request are allowed by state law.
Sure, if there's 60 frames in 1 second of footage and you want 30 minutes of footage, that's a lot of frames that need to be redacted. Is body worn footage exempt from public record if it is in our hands, meaning we're reviewing it based upon personnel?
That's a good question, and I don't know that I can answer it, kind of give you one answer, but that is part of the analysis. So is this is this body worn camera footage that has nothing to do with personnel disciplinary investigation? Perhaps most of the footage is not exempt from disclosure. If it does, then perhaps all of the footage is exempt from disclosure, at least until the personnel investigation is concluded, or in the case of an officer, either way, it would remain exempt. So yeah, there are often kind of multiple pieces to the analysis of a public record, especially the types of records that the CRB tends to see.
Thank you.
Alan, do you have another question?
I do, real quick. Thank you, Lauren. I appreciate it. And I'm gonna be real quick with this one. But based again on my scribbles, am I under any obligation to put any identify that these are Lyman's notes or the date or any this, or can I just drop off a yellow piece of paper with 17 words written on it and say, this is a public record to the auditor? Because if there were such a thing, that's what it would look like.
So the record is the record. You're not required to create it in any particular form. And you're not required to, create or amend any new records in response to a public records request. There may be reasons for either for you or for the auditor later to add some of that identifying information to make it easier for them to kind of go through records and understand what they are. But you're under no obligation to title it in a particular way. Or
Does the auditor want that from us? Like, my notes from this date or this meet,
I want you to go back through every single one, Alan. No, just kidding. No, when you bring those to us, I mean, especially if you've had some from, the last several months, but when we get them like within a month of hearing the case, for example, we'll be like, oh, those are probably related to that case, and we'll file them appropriately with the right IA numbers and the right CRB meeting identifiers and all of that. If we don't have that, we're just going to do our best, but we're going to retain it. So no, I'm not going to ask you guys to annotate your notes or footnote your notes or anything like that, but we will try to retain them in a way that makes the most sense.
Thank you.
Mm-hmm. And Jose, just quickly, I was going to mention on the body cam requests. So those are really an interesting area of public records law, as far as when, for instance, someone is a criminal defendant and there is body cam footage that is evidence in their case. As part of that discovery process, they'll typically be able to watch that video, and they would access that through their attorney. It's not a public record because they're involved in that as well. Is that right, Lauren? I mean, your face is a little skeptical.
no,
Okay.
it is. So, right. In the case of a criminal defendant, they don't go through the public records request process typically, which has, all the state law requirements that we just talked about. There's a separate process called the discovery process for a criminal prosecution, and it has slightly different rules about when the city has to give things or not give things, because the criminal defendant has constitutional rights, et cetera. So it's still a public record for purposes of public records law. It may be exempt from disclosure under public records law, but a criminal defendant may have access to it under the discovery rules. So
Yeah, she said it way better than I did. I'm so glad Lauren's here.
well, thank you so much. Unless there are other questions from the board, I don't need to take up any more of your time. I know you have other things on the agenda, but I appreciate you having me come to talk to you. And if there are public records or meetings questions that come up for you, or once you've had a chance to kind of look through that handout, if you have questions about government ethics or election law restrictions, or it's a pretty big election coming up in a few months, feel free to reach out. Probably start with Leah or Lindsay, but they certainly can connect you to my office if we can be helpful.
Thank you. Thank you for coming.
Thank you, Lauren.
Thanks, everyone.
Thank you.
All right, it is time for our break. So we'll do 10 minutes. Does everybody want 10 minutes? Yeah. So at how about 6:24 we come back?
Sorry, I just remembered I should re-record. We're being recorded again. Did we read the order aloud so Monique knows when she has to go? Because I don't know that she can see the chat. Okay.
I did, and we can jump in. Or Clay, when you're done talking, if you remember, you could just say, Monique, you're up. Thanks. Okay, I think we're ready to see the presentation.
Alrighty, here goes. Okay. So we got a case review for allegations of lack of courtesy and excessive use of force. So the summary of the facts, and I'm just going to read it. Officer A was dispatched to a trespass call. The reporting person informed Officer A that there was an unidentified person, citizen B, interfering with the delivery door at the RP's work establishment. RP said she contacted citizen B and asked him or her to move. Reporting person says citizen B responded with profanity and refused to move. So the RP called Eugene PD and reported citizen B. Officer A arrived and interviewed the RP. RP explained citizen B was combative and refused to leave the place of business. RP told Officer A he or she did not want to press charges for trespassing. RP just wanted citizen B to leave the business. Prior to contacting citizen B, Officer A requested assistance. Officer C arrived at the incident location and the two officers contacted citizen B. Citizen B resisted the officer's efforts and a struggle to handcuff citizen B ensued. Based on citizen B's actions, he or she was arrested for trespassing and resisting arrest. After citizen B was handcuffed, Officer A and Officer C moved him or her in front of Officer A's marked Eugene Police Department car in preparation for transport to the Lane County Detention Center. Officer C and citizen B engaged in a back and forth verbal exchange, and as the discussion progressed, it escalated. Citizen B made repeated claims about police brutality, and Officer C replied with resisting arrest statements. During the interaction, citizen B turned his or her head towards Officer C. Officer C placed his or her hand as a barrier between them, and Officer C's hand contacted citizen B's head in the right cheek jaw area. During an IA interview, Officer C stated that he or she placed his or her hand in a defensive position to protect himself or herself from citizen B, specifically to protect him or her from being spat on. Officer C stated that he or she had been spat on in his or her capacity as a police officer, and on one occasion was infected with swine flu from being spat on. So the allegations are courtesy, that Officer C failed to be respectful, courteous, and considerate towards citizen B after arresting citizen B for trespassing. And the second allegation is use of force, that Officer C used force in excess of that which was reasonable under the circumstances when he or she struck citizen B's face after citizen B was detained in handcuffs. So the adjudication recommendations are there. And the issues for discussion are all the normals, the complaint, intaking, classification, monitoring, the policies, training considerations, and then going over the adjudication recommendations. And so here are the materials that were provided for everyone's review. And then I will turn it over to y'all for a discussion. So I'm going to stop sharing right now.
All right, thank you. The first part that we'll talk about is complaint intake, classification, investigation, and monitoring. I will start this off. My question is, it feels like I'm curious why de-escalation wasn't something that was investigated or alleged or talked more about. So I'd like to maybe hear the thought process of that classification of doing courtesy instead of de-escalation.
So I am trying to remember, but I definitely remember talking about it. As you know, de-escalation is something that I generally do a lot of talking about and consideration of. And in this case, I don't know. I mean, to me, it felt more appropriate. It felt more appropriate to say that this person, the officer, was losing their temper, sorry, not temperature. They were just This is how it felt right to me, I guess. This felt discourteous, and then the push towards the face definitely just felt like force. And I will say, we've talked a bit about how the de-escalation policy language makes it's a little difficult to investigate. It's a little difficult to adjudicate, as far as it invites a standard that is not as standard as the use of force review standard. So this felt right to me, but I'm very interested to hear from you all what you think.
I guess I was more interested in the why courtesy instead of use of force. Like courtesy instead of de-escalation. Use of force made sense to me.
I don't know. I think to me, it felt more like a loss of temper, a loss of patience, and it didn't feel to me like a technique. When I watched that, when I reviewed the report, it didn't seem as though this officer was choosing to use their voice as a tool of influence, right? To me, it felt like they were losing their temper and being, discourteous. So it didn't, I don't know. I feel like when I look at de-escalation, it's like I can look at a situation and see there was a choice here, right? Like there was a choice where you could have tried to de-escalate. And in this one, it didn't seem like there was all that much. That sounds very harsh, but it didn't seem like there was that much intent or that much thought behind it. It was just like, it felt like it was just a reaction rather than I'm going to go through my tools and try to figure out which is the right one to use. Does that make any sense?
I think so. Yeah. Okay.
But
So
feedback.
I think it might, I want to hear what other people have to say, and I might have more to say about it in the adjudication recommendations, but I think for now that was a good answer, and I appreciate that. And I don't think I have any other things about this. I think that I'm glad that it was something that was investigated, and it was done well. So I'm going to move it on, pass it on to Alan, and then I'll say again the order. So me, Alan, Bernadette, Jose, Clay, and Monique.
So on the issue of intake and classification, I note that the use of the excessive force came from the auditor. Initially, it was the single one, and that from a process analysis standpoint, I appreciate that. And I think it seems warranted from what we saw. My question on that particular allegation, I don't remember where, but there was some commentary in someone's report about the repeated head strikes during the arrest with Officer C of Citizen B. So I'm curious if that was considered as part of the excessive force, and why that only drew it said there was a mention that policy says avoid the head and the parts of the body, and go for the torso if you can, and there it just seemed cursory, and I'm just curious, was it considered to bring the force allegation to consider that piece of force?
That is a good question. I'm trying to go back through correspondence to see. I recall having discussions around all of that, and it seemed to me that are you talking about the head strikes when the person was still on the ground before they were in handcuffs?
Thrown on the ground. Someone made a comment. It might have been IA. Someone in their report said, well, there is a policy, avoid the head, but it just never seemed, it wasn't part of the excessive force charge, I don't think. So
it
just
was
curious.
Yeah, I would say, from what I recall, and what it was that looking at that, and Rob, feel free to jump in, because I think you were, I can't remember when I got help. But I know you and I had those discussions. I think you and I had those discussions too. Why don't you go ahead and jump in?
Yeah, it was ruled the scuffle. It was ruled a justifiable use of force when it was on, and the location where the Citizen B was kind of tucked into that corner. It was a very difficult place to handcuff them, was the discussion that we came to. And that was viewed separately, because in the instance that was the allegation, Citizen B was handcuffed.
Yeah.
So it was over.
Thank you, Rob.
Yeah, no, thank you. That I appreciate that. And I think it kind of implicates a little bit what Carolyn was talking about with de-escalation in terms of when when citizen B was on the prone on the ground. Those are my comments. Thank you.
I always kind of thought de-escalation was, in my mind, it's like before they're taken into custody, that, you know, it's like the de-escalation techniques are for taking somebody into custody. And so since the vast majority, or for me, all of what happened here that I felt like I should be looking at was after the person was in handcuffs. And certainly, I think for me anyway, the de-escalation policy didn't make as much sense in this case because they were already in custody. I did have a couple questions though about the monitoring, because there was a supervisor that showed up on the scene, and we have that person's camera video we were able to watch actually, and then there was another person that drove up after the person was finally placed in the car. I was just kind of curious as to how come that person that helped with the custody wasn't interviewed at any point in time. Because I think it was a supervisor, so I would think it would have been somebody that would be able to say.
That officer
Hey.
retired.
So we can't contact them to have a question? We can't?
They were contacted and they declined to be interviewed, and we can't compel them to be interviewed after they're no longer an employee.
Absolutely. Okay. Was that in our packet and I just missed it? That they were requested?
I think there was a mention of them being retired and not contacted, but I don't know that the full extent of, there was.
I did see that they were retired. I just didn't know when the retirement came in relationship to all of this.
Yeah.
Also, I know that you disagree with the chief, and I'm trying to figure out the timing of, it seemed like the whole chain of custody or chain of command made their decisions before you wrote anything. So, but I assume there were some conversations.
There were
that went-
conversations.
Okay.
Yeah, so the immediate supervisor spoke with Rob. We made it clear that we would be disagreeing. Rob drafted an excellent memo, and the chain of command did their memos and put them up the chain of command. And this is something that we've been working on because IA has changed our process, and Cindy can speak to this more, but they have a more expedient process of approving and signing these now because they do DocuSign. So you can see the little approval list, right? But we are still finessing the timeline as far as making sure that we get in there at the same time. So they knew that there was a disagreement coming.
Okay.
And that's where that landed.
My other question is, and maybe this is more of a tactical question, are there different handcuffs out there? Because I can't understand why the officer that was handcuffing was having so many problems using the other officer's key or correcting. And Rob, I know that you've used handcuffs a lot in your career, I should say.
So handcuffs get tweaked when you use them.
Okay.
And most people, I was no different, had a particular set that I liked, and I would guard them with my life if somebody else borrowed them, used them, transported somebody with them. So there are different types. Most people have either a hinge or a chain, but they're different brands, and they just, yeah, they're slightly different. So Officer A wasn't used to using the ones that Officer C had, so had a little bit of trouble with the double cuffing, which is the locking mechanism to keep them from
Right.
cinching down. So yeah, there's slight differences, and then they wear.
Okay. I mean, that was clear that Officer A was having troubles with it, which I think exacerbated some of the problems here. So yeah, I don't have a problem with the classification, what it was decided. I think it made sense to me. I can see where Carolyn would think that what it could, I mean, I could see how other people would think that, you know, de-escalation might make sense, but to me, because they were in custody, and as to the head strikes, I thought it was just the person being handcuffed that was saying they were hit in the head. I don't remember actually seeing any. I mean, I saw a scuffle, but I don't recall there being head strikes to get the person in custody. But I could be wrong because this was over a week ago that I watched it. So those are my comments.
I think my comments are going to be typical for how I present mine, and the affect that I bring here. I have to say this one really ground my gears. I'd like respectfully to know what Sergeant Maloney and Chief Skinner see in that body-worn video that constitutes courtesy. What I saw failed to be respectful, courteous, and or considerate at nearly every second of that interaction. When approaching a citizen, for example, is kicking someone who is sleeping considered standard procedure, respectful? Can kicking somebody who's asleep, whether they're blocking a door or laying in the middle of the street, be considered de-escalation? I know that's not part of the thing here, but this pissed me off because there's some really creative framing here about what Citizen B is doing and how they're disrupting. They're not in front of the door. They're by all means just sleeping there. And sure, do we want people sleeping on private businesses? Does it disrupt our like sense of propriety and like our like aesthetics about what a city should look like? Sure. But to me, this thing which comes up again and again and again is it turns on a question, which is, what do we want the role of policing to be in Eugene? If we want it to be about busting skulls, fine. That's okay, cool. I'd serve my role in the Civilian Review Board here to uphold that kind of like, if that's what we want. But you know, I had questions about de-escalation here too, and I now understand why, Leah, this was the courtesy policy, because to me, when I reread that courtesy policy just now, I was like, I see that at every single interaction here. When sorry about that. You know, at 8:24, Citizen B says to Officer C, "You socked me in the fucking face, police brutality." And the officer says it's called resisting arrest, which was noted already in the presentation. I'm just not sure after watching this video how what we saw can be considered resisting arrest when contact was made at 2 minutes and 2 seconds and hands are on the person at 2 minutes and 18 seconds, which is 16 seconds go by. And the striking happens at 2:18 and you can hear it. And I don't know, I'm just wondering, does it seem appropriate after you watch the video to be striking somebody who's already on the ground, Citizen B, in the head while they're laying on the ground? I would love to hear an explanation as to how the use of force there is commensurate with the context. So yeah, I think that the courtesy is the lesser of the allegation, while it's certainly appropriate. But I have, and I also think that the second allegation, we're not talking about this, but I'm gonna push harder on that one when it comes time. I just have a question here. Are we allowed to know how many prior allegations have been directed at Officer C? Because if I'm not mistaken, I've seen their name twice before. I don't know if am I allowed to say that?
You have, and you are, just don't say the name.
Yeah, Officer C.
Yeah, but no, I think that's something that we've discussed on this group in the past.
It's a pattern.
When we've had folks who come up a lot, yeah.
And now it's not just a pattern, it's like a pattern of like quick to jump somebody.
That was the end of your comments, Jose? Okay.
Yes, sorry, I was just dropped the mic.
No problem, just ghosted. Okay. In this category of information, I agree there's a little bit of, or this category of what we're talking about, I agree I have some question about whether there could have been a classification related to what happened before the person was put in handcuffs. I would describe the interaction differently than I think Jose did. I don't think it was excessive. What happened very initially, you know, if you say a kick without seeing the video, it could be mentally interpreted one way, where I think the Officer A was, I think I got that right. Officer A was not necessarily being super aggressive, but regardless, that whole sequence of events happened so quickly, and I think it could have not happened so quickly. And so in that regard, that idea about de-escalation or other tactics or some other realm of issue, I think you probably all discussed maybe that portion of the interaction. And it would be interesting to know your take on it as investigators. After the person is in handcuffs, I think the courteousness and use of force classification of those issues makes a lot of sense. So my only question is sort of before that chain of events and whether there were issues that were looked at.
Yeah. From what I recall, we looked at the whole interaction. You know, we always look at the whole interaction, and it's one of those things where, like, I found in doing this job that the Supreme Court standard of use of force is not often what the community standard of use of force is, right? It's a reasonable officer standpoint. It's given, you know, what is known to the officer through their training experience, what, you know, and that is, you know, what assumptions they're making through their training and experience. It is very weighted in favor of the user of the force, right? So I wouldn't say often, but when I do recall when we talked about this one, it was easy for me to see it from the get-go what the arguments would be that would make this a reasonable use of force from the perspective of the police department. And I do try to investigate what I look at the beginning as, this is to me clearly a violation, right? I don't want to go through the whole investigation for something that I know from the outset is not going to be a violation of policy. So when I looked at that, when we talked about it in the beginning, I felt that I could see where that was going to be a justifiable use of force. And I was more I will say also, this happens to me sometimes where there's something else in the video that I'm just sort of blown away by. So I think for me, I am not used to seeing that level of arguing and like the face thing with someone who's in handcuffs. I would say it's highly unusual. I've been doing this for a long time and it does not happen very often. So I think that was also part of it, probably, is that stood out to me so much as is something that I felt needed a closer look. And the other one, I could see where it was going. So I don't know, Rob, if you have something to add to that, that's fine, but that's what I recall.
So if I can just make one more comment before Monique, it's your turn. In response to that, I would say the challenge that I found in my previous work on these kinds of issues was, well, the use of force was justified, but the interaction that created the justification was provocation on behalf of the police officer. And so where do you draw the line of where escalation, where there's a fault, and can you investigate that? And so I agree that once the struggle ensued to put the person in handcuffs, the use of force seemed to be justified to get that done. But was there a need to move toward putting that person in handcuffs so quickly? So that's a challenge. I don't know if there's any solution to that.
No, I really
legal state.
I appreciate that. I appreciate that comment, and I appreciate that insight, and I agree. It's a struggle. Monique.
Oh, go ahead. Whenever Leah finishes talking, Monique, it'll be your turn.
So I also agree with Carol that this seemed to be like there was a de-escalation issue, and that occurred at the very beginning. The officer A definitely didn't kick the trespasser, but she or they did tap them. And I think that was not helpful, and it kind of like set off a chain reaction. And I didn't realize that we were going to be limited to just when the suspect was handcuffed, because a lot of my issues are with the slaps and punches and knee strikes. And every officer, so Officer A, Officer B, and the internal affairs officer said that Officer B delivered open and closed hand strikes. So that is confirmed. I didn't realize that it was appropriate, or I still don't know if it's appropriate, in an offensive manner to punch or slap someone or to knee them. Is someone able to answer that?
Sorry, yes. So those would be considered, as unusual as it is for those of us who don't have a lot of interactions with police, those would all be considered focus blows and a low level of force.
All right.
Yeah.
But I was happy, I will say, that I felt discouraged reading the IA officer's memo at the end. I thought his interview, I thought it was sufficient. I was happy until I read the adjudication memo. I was a bit discouraged, but I appreciate that you didn't concur. I think that that's important.
Thank you. And I want to just be clear, the IA investigator writes that investigative report, which is it's the fact finding. And then the officer's immediate supervisor is the one who makes the adjudication recommendation. So we try to keep that separated between the person who's trying to find the facts and be that objective observer and investigator versus the one who's talking to us and giving their opinion. But we do both. So I know it's confusing, but I just want to make that clear.
Thank you for that.
All right, let's move on to the next part. So EPD policies, practices, and training. We'll do the same order of people, but this time we'll start with Alan. So Alan, Bernadette, Jose, Clay, Monique, and then me.
Thank you.
Sorry, Alan, don't mean to interrupt. Well, I do mean to interrupt, obviously. But did Rick have comments split out by order, or is it all just one at the end?
I have comments from Rick that I'll just do at the end because it doesn't seem to be broken up the way that I read it.
Thank you. Apologize,
I mean,
Alan. I just wanted to get it in the order if it was.
Is that true? I mean, Leah, what do you think?
Oh, she went away.
Do you think
Sorry? Yes, I think that's fine.
Okay.
I am not sure that I followed that, but I'm going to go ahead with policies, practices, and training. I'm going to say that this is where I think I'm going to riff on Jose's piece and say that the encounter was a fail. And Jose pointed out the times. It went from, I mean, I get it for officer safety that Officer A nudged with her foot, but still, it's a sleeping human being and not blocking the door. And Jose gave us the time frame. Within a very short period of time, there were two officers with hands on in a struggle with this person. And if we can't take a step back and say that it shouldn't happen. I mean, I know that, it's not our role to nitpick everything, but something went wrong in this encounter. It shouldn't happen. So it's definitely what happened before and not just when the person was in handcuffs. And then to further riff on Jose, I'm harping on the fact that when you do this in a vacuum, when you just look at an incident and you don't recognize that we've seen this same name a couple times, what's the point? I hope that EPD is keeping track and has a metric and has human resources that is going to either recurrent train or but if the discipline process is this simple, straightforward analysis and it's within policy, but the same guy the same person keeps skating by, so I think that the encounter was a fail in terms of practices and training. I think that it was it only happened and we're only here because Officer C kept arguing, I think for sure, Officer C, I think you can protect yourself from getting spat upon. I do believe that is an appropriate reaction of, the physical force necessary to turn a head, but the head would not have been turning if the arguing had just not been persistently happening. So there's training and practices. I just think this just never should have happened. I mean, I don't know how you wake someone, the kick, but it, and then just the last point I want to make is that when I read a report that the officer A had to avoid getting injured from the sleeping person's response with their foot, it loses credibility completely of the entire reversion of the whole incident. I'm just like, okay, you know, that is not what happened. That sleeping person just kind of went, you know, put their foot out, but nobody was almost injured. So, you know, I just, when I see that, it's troublesome. So that's what I got. Thank you.
So I'm not sure that there's any really policy procedures training that needs to be revamped or anything. I think the officer Officer A, I believe, is 6 years with the force, and Officer C is 15 years with the force. You know, at some point, yeah, it's like, how much training can you do with somebody that far into their career and hope for a change of behavior? I mean, it doesn't mean that they shouldn't try to retrain. I'm not saying that they shouldn't try to retrain. I'm not saying that at all. I'm just saying that it's like, given the sequence of events, and it's like, what's that should be coming into EPD's thought processes with individuals, that, you know, it's like, it's not just what they do, it's how long they are into their career. That, you know, when you're talking about a reasonable officer standard, you know, shouldn't we really be talking about a reasonable officer's, you know, of 2 years is different than 8 years versus 15 years. And so, you know, if this person had 2 years on the force, we'd be looking at it differently than having 15 years on the force. So I'm not trying to say that this person shouldn't have any training. I'm just kind of wondering, it's like, what's EPD going to do to train this person? It would be nice, right, that this would be corrected. But what do you have a training as? I have found sometimes we do trainings for lots of people, and the person that needs to be trained is the one person. And we need to target the training for the one person. But in shops such as police departments, when you have unions involved and training involved, I'm not sure that it's always possible to do a directed training with one person unless it's coaching or there's a violation of policy. So given that they didn't find a violation, we're kind of, you know, it's like that I'm chicken and egg sort of thing. There was something that, this is why when we're talking about, we don't want to see this in a vacuum with regards to, you know, an officer, what their background is. I'm also wondering, we didn't have enough information from the person that contacted the subject that got arrested. There wasn't enough conversation to know how long was this person out there talking, asking this person to leave. So when we say that, you know, they went up and woke up a sleeping person and kicked them, I think, you know, we don't have the whole story. You know, it's like, yes, they're laying down. Yes, the person is appearing in the position of sleeping, but we don't know. I mean, was the person, you know, that was at the storefront, were they contacting this person and talking to them for, you know, 20 minutes, half an hour, you know, trying to get them to leave before they contacted the police? Given the location and the number of people they probably interact with, I would think there probably was a lengthy conversation. But we don't have that information, so it's speculation on my part to say that. But that's also what makes it hard to know, you know, why they moved so quickly. You know, it's like, what was going on before that? So I definitely think that, yeah, we can't look at this in a vacuum, and that coaching this person is a good thing. I wished it would have happened by the person who retired that arrived on scene, that person would have just said, quit jawing at the guy, gal, person. You know, it's just like, it's not obviously not doing any good. I mean, I guess it's like, you know, arguing with your 3-year-old. It's like, at some point, just stop and walk away. So my thoughts.
Yeah, I appreciate your comment, Bernadette, in the sense that I think we've got a lot of officers who don't need to be trained in dignifying human subjects that they approach on the street. So do they all need to go through training because one officer continues to do this? No. But okay, so at one point in the video, body worn video, Citizen C says, do you remember this? What city am I in? Is it drugs? Is it a mental health crisis? It's something that's indicative of this person. This is hindsight, of course, right? Perhaps it was probably more appropriate to call cahoots in this situation. But nevertheless, I think this is indicative of a problem in EPD here, be it policy, be it training, be it leadership, because I have a real problem with the way that that this was framed. And it was framed in such a way that it is skewed toward, it looks to me like it's skewed toward protecting officers. And look, call it a kick, call it a nudge, call it whatever you want. In what setting is it okay to approach somebody with your feet like that? It's undignified. If we're going to have standards here about public contact, right? Like, sir, you're an adult now. You can't be sleeping in the streets like this. Then why are we taking it so easy on a repeat officer like this? I think we all have some like reasonableness standards that, like, sure, like public figures, say teachers, shouldn't approach kids in that way and nudge them with their feet, right? Not appropriate to do that in any other municipal settings. We would say it's undignified. Would that, I don't know. But at the same time, I don't want to go after somebody's job, but we have the public interest at hand here. And that's really difficult to weigh, like public interest, like, you know, not necessarily trying to like disrupt or ruin somebody's career. But I think that with respect to the hard work and overwhelming amount of like unprecedented historical problems that EPD is dealing with in unhoused peoples, right? Coronavirus, social unrest. It's not good enough right now. And so I don't know. I'm kind of looking for others to help me find some language to talk about this. Like, if it's structural, is it policy? If it's structural, is it training? Is it individual? Then what do we do about individual officers? But I think it would be like, it behooves us to pin that down at some point. Okay, sorry, I'm done. Clay.
Yeah, I'm not sure there's a particular policy or procedure that needs to be revamped. I think training is always an option, and I agree with what's been said about how can you target training to individuals. I mean, my mind works in metaphors, and for me, or personal experience metaphors, and for me, I see this kind of behavior a lot of time on the soccer pitch, where people feel aggrieved by a decision, or like two opposing parties, even just soccer teams, have anger happening because they're frustrated by a play that just happened, and then that kind of behavior comes out, and you see that all the time. And so people are rude sometimes, and it's this thing that you have to either get training out of or become an adult and realize that you don't have to be mean to someone to get a point across or rude, you know. So it's sort of individual development. And I agree with Bernadette that after 15 years you would hope that there would have been conversations with this officer that led to a maturity that doesn't require us reviewing their cases multiple times because of courteousness. So additional training, I think, would be great. And if it could be targeted, that would be excellent. And there's also personality in the mix, and a recognition that, you know, who knows what happened before or the week before for this particular officer, and what are they receiving in terms of support to deal with that, if that's what the issue is. Because we all know that this is probably happening, that there are probably a lot of instances that grate on police officers every single day. And so is it training, or is it also support resources for emotional health? Yeah. That's all I have to say. I think training of some sort would be great to look at. So Monique, you're up.
I agree. I think focused training would be helpful. I don't really have any other comments about policies and procedures, other than it just feels like it just feels like this was swept under the rug, and maybe that excessive force wasn't taken as seriously as it should have.
All right.
Sorry, I just feeling the urge. This case brought up a lot for us around early intervention and those conversations that we've been having around early intervention. And we are still working on that, trying to come up with something that's workable. But I think it's also sort of interesting because it is also an example of how the system that we have right now does sort of work, because our department is so small and we know the names that have come up regularly. And as far as, I'm not saying it 100% works, because we see them again, and that's a problem. But I think that there is an acknowledgement there that we are able to identify that, we're not such a big department that it gets lost in the mix. It's definitely noted. And I don't really have an answer. I just, those thoughts come up. I think something I spent a lot of time thinking about is, how do we do better coping mechanisms? Like Clay, it's like what you were talking about with soccer, right? It's people get frustrated, people get angry, people get exhausted. But when those people have a gun and a badge, it's pretty unacceptable to use any of, to take that out on anybody at work. So it's just how do we end up in a place where it's about like changed behavior, and it's not necessarily, maybe it's punishment, maybe it's coaching, maybe I don't know exactly how to always achieve the magical changed behavior, but I have a limited number of tools, so I don't know. It's just something that comes up a lot, and I don't really have clear thoughts. I am going, however, to a CLE next week on early intervention systems and police departments, so I'm hoping I'll learn something helpful, and I'll stop now.
All right, my comments on policies, practices, and trainings is similar to a lot of people's. I think the thing that really stood out to me is remembering this officer's name. Going back 5 years, it's many, well, it's multiple. Many is maybe an exaggeration, but we've talked about this officer quite a few times, and the majority of those have always been de-escalation or something similar to de-escalation. So I think that's part of why I was kind of really trying to hone in on why that wasn't one of the allegations this time around. Because to me, it seems like a problem that this person tends to not only fail at de-escalating, but this officer tends to escalate, in my opinion. I think that there have been many times that we've seen this officer interact with somebody, and it could have gone a very, very calm way, and it went completely differently. So I don't know that, I would hope that the first time we talked about this officer, the first time that the auditor's office encountered them, some training happened. And then I would hope that the second time some training happened, and the third time some training happened. So I'm wondering, is training even effective at this point? So it just brings up the question of what's the next step? And then that being said, I think that I'll publicly say here that I think it's not helpful that the disciplinary action isn't public or clear to us, because I think that would really answer a lot of our questions about this kind of thing. If that was a public thing that we had eyes on or access to. And then I guess the next thing, this might actually kind of bridge to adjudication recommendations, but as we see here, chain of command said it was within policy, the courtesy. I think, and then
Yes.
you sustained it. So was there any, I mean, you can say this generally, was there any disciplinary action taken when the chain of command is saying that it's fine, even though you disagree, or is the,
In general, there will be disciplinary, well, corrective action is happens when there's a sustained violation.
even from you?
No,
Okay,
the chief is
only
the
if
one
it-
who has the final decision.
okay, so we can assume that with this, there was no corrective action.
There was no sustained policy
Okay.
violation in the end.
All right. Okay, well then I'll talk more about this when we get to the adjudication recommendations, which we are at the adjudication recommendations. So we will do the same order. We'll start with Bernadette. What I think I would like to do on this one, since there is a disagreement, I think that it would be good to go do a round of just kind of comments on adjudication recommendations. And then at the end of that, I want a more specific, like on adjudication 1, I agree or disagree. So we can have that in the record. So this round can be, I mean, you can say that, but I'm going to ask you again in a more succinct way at the end. Does that make sense to everybody? Okay, so Bernadette, and then Jose, Clay, Monique, Carolyn, Alan.
As people have made comments, one of the things that kind of has come up to me is I think there's a lot of compassion fatigue going on in society right now. I was someplace over the weekend where there were a lot of homeless people, and they were being so rude to so many people. It was the bottle drop. It was like, and it was just like, I mean, they were just like yelling at people about how they were putting their bottles and cans into the bottle drop. And I found myself just really frustrated because I was in a situation where I can't say anything because it's like, it's obviously going to escalate. They're not going to hear me. Is it drugs? Is it mental health? What's going on? And so it was like seeing this, and you just kind of go, how do you work in an environment day in and day out where you're constantly trying to figure out how to engage someone that probably has drug and alcohol or mental health issues? And it's like and so it's not excusing at all, because I agree with the auditor's office that the discourtesy policy was violated here. I mean, it was just like at some point, Officer C needed to just be quiet and just figure out the handcuffs and get the person in the car. It was just, it just kept going, and there was nothing productive about it. Much like, much of our society, it's like, you engage with somebody who disagrees with you on a point, and it's like, you can't have a rational discussion about it. You just end up, it just ends up falling apart, and, comments get thrown back and forth that are just not okay, or at least they wouldn't have been okay, 20 years ago when, we were, able to talk to people and have a disagreement with them. And so I think it's just, it does not excuse this officer's discourtesy in the least bit. It came to light after reading the whole case file, and then over the weekend having these contacts and just going, I'm so glad it's not a career choice that I made in my life, because I could see, it's like you try to cope with it, and what do you do? And so that's why, I appreciated the presentations we had a couple of years ago, that they talked about all of the things they're trying to help officers do, to cope, because it's like all of that was before, we had COVID. And then you bring COVID into it. And, it's like as many of these officers have gone through the whole, it was like, started with the spitting and HIV AIDS, and swine flu and COVID. And you just, again, it doesn't excuse it, but I just wish the officers, I don't know how many of them take advantage of those resources that are there for them. I hope it's more than we think it is. But I don't know that there's a really way to do that. I guess one other thought that came to me is, does the auditor's office keep any kind of statistics, or maybe it's the police department, with regards to when in a shift allegations are made? because I just think it would be interesting. It's like, if all the allegations are always being made in that last, hour or two, or, if they're made over the course of, the whole shift, obviously, that's a big problem, but it's kind of like, if they're always happening at the end, just kind of.
Yeah. Yeah, no, that's an interesting question. We don't have a little box that's like, what hour in your shift did this happen? But we know what teams people are assigned to and the times that these things happen. I think the issue is, and Cindy can correct me if I'm wrong, but like at the end of the year, when we do our annual report, or like whenever an officer changes teams, they're changed in our database. So like, if the officer has changed teams since the allegation happened, right, then they would be working at different times, and we'd have to do some backfilling on data or figuring that out. But we might be able to, that might be something we might be able to figure out.
Those are all my comments.
Hi. I want the frame for my comments to kind of always be this, no matter how like finger wagging I get about things, which is, what do we want policing to look like? I'm an academic, and the first place that I want to go is to ask questions like, at what point do we use violence to maintain peace? Well, at some point we have to, sure. We have to accept that that's going to be a part of maintaining peace. But at what point does that process become the other one, right? Part of the job is to use force. It has to be. There's a social contract that we all sign tacitly, and we live by those rules, and it's our job to be informed of them, sure. Part of the job of the officers in our community is to maintain courtesy in maintaining civic order. I'd like to just read the courtesy policy, 103.5.8. Employees shall, on all occasions in the performance of their duties or after identifying themselves as an employee of the Eugene Police Department, be respectful, courteous, and considerate toward the public, their supervisors, their subordinates, and all of their employees. But D is where it really stands out to me. Employees shall use tact in their interactions. Now, tact is defined as adroitness and sensitivity in dealing with others. And adroitness is cleverness or skill. I think we witnessed neither of those things in this interaction, cleverness nor skill. I think the appropriate metaphor to follow Clay here is that the wrong tool was used for the job here. There was a sledgehammer used when a scalpel could have done very well the job, or a screwdriver or something. But I'm just, why is one officer losing sight of like half of the job here? And it's not just one time, it's multiple times. And I do get it. Like, we are all, I absolutely agree with you, Bernadette. We're all experiencing some kind of fatigue here, but the stakes are higher for some of us than they are for others. And like, if you don't want to do that part of the job and you want to hurt people, you can make a deployment or something. You don't have to use tact necessarily in that regard. But in a community like ours, where we have an unprecedented amount of unhoused people, we're going to need adroitness in how we address these issues. Sorry, over now.
Yeah, regarding this section of the topic, I am surprised that the courteousness was not sustained by the police bureau. And I'm glad that you disagreed with that and wrote a memo saying as much. That surprise is further compounded by just what I thought I had an understanding of in terms of expectations of the police bureau. And so it would be good to hear the side of the argument that that thinks that this is courteousness, or that it's a within policy courteousness, because it just feels, I mean, this may not be an extreme situation in my mind, but it is obviously discourteous, and it's a pattern, as we've all talked about with this particular officer. And I agree with what's been said about the initial part of the interaction too. It's probably not the best way to approach a person to first, use some sort of touch or physical force, even if it's minor. A short conversation might have gone a long way, but we don't know. We don't know what the outcome would have been in that case. So yeah, the discourteousness, I think, is quite surprising to me that wasn't sustained. And I would disagree with the police bureau on that, and agree with the auditor's office on that allegation. Use of force, the reasoning to me makes sense for the use of force that was examined. And as I stated before, the use of force being confined to after the person was in handcuffs is logical to me based on the law around use of force. Not logical to me based on a human being, but I believe that it was within policy, not necessarily unfounded. So I would again agree with the auditor's office and disagree with the police bureau. And we will come back to do that, I know, but I just thought I'd state that. So Monique, you're up.
Yeah, and I mentioned this, I think the first time that I spoke, that I did not agree with the adjudication, and I appreciated that Leah did not concur. And I think that's really all I have to say.
All right, so I think with the adjudication, I found the adjudication memo from the sergeant and then signed off on by the chief, right? I found it to be a little bit offensive at times, actually. I think that there is a part where it says officers must use tact in their interactions, control their temper, exercise patience and discretion, and not allow themselves to be provoked by the actions of others. It's really interesting to me that they spell it out so plainly there, but then they go on and say, you showed, or it's in second person when the sergeant is writing it, but then it's switched. So I'll just read the second person one. You showed control over your temper. You can be seen talking calmly and appropriately to officer. The letters are all confused at this point, but during your discussion with the handcuffs. So why does it matter how the officer was speaking to the other officer? That's not what's at play here. And then there's the argument about how officers should be allowed to raise their voice. And I think that it goes beyond raising their voice, obviously. And then the other thing that I felt was just kind of inappropriate in the adjudication was, or actually in the investigation overall, it seemed like there was a lot of discussion about profanity and derogatory statements. And maybe that's like a huge part of the courtesy policy, but that it almost seemed like pulling the wool over your eyes of like, they didn't use profanity, they didn't use derogatory, so it's probably okay. But I think, and I see that you're unmuted, Leah, so I'm excited to hear what you have to say. But I think it's inappropriate how much in this adjudication memo they go on and on about how they didn't lose their temper and they were calm. Because it was clear by watching the video that the temper was lost. And this wasn't the first time that we've seen this officer lose their temper. So I just found it a little bit offensive. Not personally, but just kind of as a public body in a public meeting. I don't know what Lauren was saying earlier about that, but so I did appreciate that wasn't agreed with, and that I feel like a more accurate representation of what happened was written in the auditor's memo. Leah?
I've been trying to find the right time to jump in with this, and I'm in a sort of weird position because I'm not trying to defend anybody, but Clay asked about the reasoning, and then you brought up the profanity and the derogatory stuff. So I think this is the right time. So I just want to say that historically, in you know the many years I've been doing this, sustained courtesy complaints have historically been for using profanity at people and or using derogatory terms when talking to or about people. Like that has been historically the sustained courtesy complaints. I also, though, we've also seen this sort of loss of temper come up. And I think the thing is often when there's a loss of temper, there's a use of force. And so perhaps historically things that were what I would also consider a loss of temper or a discourtesy have been looked at as a use of force, right? But anyway, I would just say that historically, I think that's the argument, right? I think that's why that's come up, is because historically it's been like, well, you curse at someone, although that's gotten looser now. Now cursing can be a tool too, or you use your derogatory terms. So to me, it was one of those where I can see that historically we probably haven't seen this that much. It hasn't been brought forward as a courtesy complaint. It hasn't been looked at that way. But to me, it, as you said, and obviously as we wrote, this seemed to fit. So thank you. I hope that is some helpful context.
Yeah. All right, Ellen, if you want to talk about adjudication, I will follow you with Rick's whole result, and then we'll go through the voting thingy.
All right, thank you. I just want to say that I think what's been implicated a lot this evening is just the limitations of the police review system of the city, because the police commission doesn't capture the risk management decisions around individual officers. And it's not really fair of us to sit around and say, we recognize a name and therefore, you know, X should happen. I mean, that's not how you assess the risk to the people and the city of continuing to employ a person. And honestly, I have no qualms in saying that's what we're talking about. And after 15 years, if any individual can't get it right and keeps repeating it, take a hike. You know, I mean, honestly, like that's what the city needs, is officers that aren't doing that. So when the auditor talks about early intervention, I'm envisioning that there is really kind of no review around the police monitoring of how all this information is collected and assessed and decided whether officer A through Z should be on the street or continue to be employed. So, I mean, that's ultimately the decision. In this case, there would have been no second allegation if Officer C had not been repeatedly argumentative and discourteous. The head turning was clearly in response to this back and forth that the Officer C should have walked away at some point prior. And I looked at all of the angles from the car, from all the body worn video. You couldn't see decisive, you know, it appeared to me that the hand movement was to block the head from, which was repeatedly turning Citizens B head. And so I agree with I think that it was not sustained, number two, and number one should have been sustained. That's it. Thank you.
Okay, I'm going to read Rick's statements, and I do have to kind of preface a little bit here, because Rick says RP when I think that he means subject or Citizen B. RP, when I say RP, know that means Citizen B, I think. And then also the letters in the redacted names sheet that we got emailed to us, it's different letters than in the presentation that was tonight. So we've been throwing around letters. I think that we all have understood who we're talking about when we're talking. I'm not so clear with Rick. So put this into the record of me just reading what Rick wrote. All right. Number one is, it appeared to me that two officers that were most involved in securing custody had two different approaches to the handling of the RP. I did not find that either violated policy in their contact with that individual. In viewing the video of the events and in listening to Officer A's versions, subjectively, they believed they were preventing unnecessary bodily fluids bodily fluid contact with their face by holding their hand up to prevent the RP from facing them at close range. Objectively, a reasonable officer could believe that any contact with the RP's upper body was incidental to that action. The reaction by RP was overdone. There was no injury to them. And then number 2, B's approach to was excellent and could not have been the source of any complaint whatsoever. Number 3, I disagree with the assistant auditor's comment that if A had not repeatedly, this is quote, repeatedly chosen to engage complainant with an argumentative, combative verbal exchange, unquote, that escalated complainant's negative behavior, that, quote, if A had not argued with complainant, it is reasonable to assume that the situation would not have escalated, unquote. This comment simply assumes too much without evidence. This comment can easily be subjectively concluded in the calm of one's office, but there is no objective evidence to establish such a conclusion. In fact, RP was hostile from the beginning of the encounter. They were rude and threatening to the store employee. They ignored a polite, reasonable inquiry from B and then kicked B as soon as B got close. They refused a request to sit up and talk to explain their situation. And they actively resisted when the officers tried to grab them by the arms to assist them in sitting and standing. The RP was verbally insulting and showed no signs of being reasoned with. Some individuals may have reacted differently on both sides of this transaction. That statement does not have objective evidence to support the conclusion that a different result would have been obtained if the officers had chosen to handle this adult individual as if they were not belligerent in the first place. I suggest that there is no evidence to establish that, quote, it is reasonable to assume that the situation could not have escalated, quote. The situation really didn't escalate from the beginning of the contact. RP's conduct remained the same: belligerent, forceful, defiant of requests, and later defiance of laws of lawful orders to comply. There did not appear to be any escalation in the contact, and the RP remained consistent throughout as described. And that is the end of Rick's comments. Thank you for your patience with my reading. All right, now we can go through and say for allegation 1, courtesy, whether or not who we agree with, if we agree with chain of command or if we agree with the auditor's office. So Bernadette.
I agree with the auditor's office that it should have been sustained.
Sustained.
I agree with the auditor's office.
I also agree with the auditor.
Oh, I also agree with the auditor's office with sustained.
And I as well agree with the auditor.
All right. And for allegation 2, use of force, we'll do the same order. Do we agree? Well, they're both the same, right? Was it both within policy?
There's unfounded and within policy. You guys could also obviously disagree with both of us.
Could you also give us a little explanation of the difference between unfounded and within policy, just quickly?
Absolutely. Yeah, so unfounded is reserved. I forget where it's defined. I think it's in the protocols. It might be in the ordinance. Anyway, unfounded is for when the incident as alleged did not occur. Within policy is when the incident occurred, but it appeared to be within policy. Insufficient evidence is when we don't have enough evidence from the investigation and we can't get enough evidence from the investigation to find out whether it's more likely or not that it occurred or didn't occur. And sustained is when more likely than not, based on the evidence, it was a policy violation. I also want to quickly say for the record, RP is used as reporting party, which I think is why Rick was using it, but that's one of those, you know, I can't remember the word, but I just want to explain that for everybody. So I'll stop now.
Jose?
So the second allegation is in reference to 800.2.
Yeah.
Okay. I don't want to make us stay here any longer than is reasonable given the context. However, did we want to do did we want to have a round to talk about this part, or did we do that already? You think?
I thought that we had done that, but if you have something else to say, I think it's fine.
Okay, I just wanted to be clear, or at least clear that we were having a conversations on the same plane with the same language here. And when I see the use of force by officers policy, 800.2.1 says pursuant to ORS 161-235 and except blah, 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 a peace officer is justified in using physical force upon another person only and to the extent that the officer reasonably believes is necessary. Number one, to make an arrest to prevent the escape from custody of an arrested person, unless the officer knows that the arrest is unlawful, or for self-defense. So it seems like folks are referring to excessive force with the like head shoving. Is that what we're discussing here? Or, okay. And it is the original, like is the approach with citizen C to not be discussed in this part, or when we're talking about the reasonableness of force?
It's not a part of it. It's just the head, the hand on the head.
I think if that, to me, what I'm hearing when I've heard you guys discussing that part is a critique of the classification and where I sent the investigation, where I directed the investigation, right? So this part to me is focused on the one that we did investigate, which was the slapping the head at the end. But I've heard that feedback and I appreciate it.
Thanks for clarifying that. Sorry, it's late in the day. Appreciate it.
That is a good clarification. So we are agreeing with, or we're talking about whether or not we agree with that what was investigated. But I think, as Leah said, you took note of the fact that you think that maybe there should have been another complaint added on to this, or it should have been part of it. Is that right? Okay. All right, Bernadette. What do you think the adjudication should have been for allegation number 2?
Remind me, the chain of command said within policy?
They said unfounded and we said within policy.
Oh. I was thinking insufficient evidence. That's where I land. I land on insufficient evidence.
I like the wild card. Thanks, Bernadette.
Yeah, it's always me.
It's a very begrudging within policy from me.
Within policy.
To be a little bit more nuanced than I have been, I think I've been talking about the whole scenario. I didn't realize today that I was going to be limited to just when he was in handcuffs. That incident towards the end wasn't the thing that I was most uncomfortable with. And so I think I'm okay with the within policy decision.
I agree with within policy, and I think that Rob clearly explained his reasoning in it, and I agree with his reasoning in the adjudication.
I think this is one of those examples that the auditor mentioned earlier in the meeting where something that maybe shouldn't have happened caused a reaction that was within policy. So I don't think it ever should have happened, but it happened, and it was reasonable. So yes, within policy.
Okay, we did it. Closing comments. Let's just do the same order and then, oh wait, no, auditor report. Sorry, Leah. I'd like to hear an auditor report.
I mean, it's okay.
It's just, there was the page break and I missed it.
Right. I'll be quick. I heard a request for updates on office space. So we have found a new office space. We're very excited. We're gonna move over to, I think it's 101 East Broadway, but it's by the park blocks. We're gonna be actually next to Legal Aid on the 2nd floor. So we are working on, signage and getting everything ready, and we will be, I think our take possession date currently is October 1st. We're gonna need to do some wiring and all the stuff that the city has to do. So I'm not sure exactly what our official move date will be, but I will keep you updated. I would not anticipate that we'll have our October meeting in our new space just because we need to wiring and moving. But potentially we would have something in November. Yeah, that's the next one. We've also talked about trying to do some kind of like an open house or something with our stakeholders, right? CRB, City Council, Police Commission, Human Rights Commission, all the people who we deal with on a regular basis, or we work with on a regular basis. Sorry. So anyway, that's that update. We are very excited about that, and I got to peek at the space on Friday, and I think it looks great. So very exciting. Employment status. I also heard a request for that. So I'm still your interim monitor. Thanks for having me tonight. I believe most of you have probably been contacted to talk about me. I'm sorry. Last update I have is currently, I think I'm on the council calendar for the end of October. Well, I'm not on there. The person who's doing my feedback process is on there for the end of October. So I did put in a request to see if there's any way to move that up. So we'll see how that goes. And I will keep you updated on that as well. We have 231 complaints through today. So we got a slight slowdown in August, which we all were grateful for. Deeply. Yes, it was nice to catch our breath a little bit. We reviewed 152 shows of force, 94 uses of force. Council was on break last month, so that was awesome. You were too. Thank you. I hope you all had a lovely time off. I'm about to sign the contract for the community portal that we're hoping to get online here soon. We had some red tape to cut through, but I think we're there. We're crossing our fingers on that. So I'm very excited to show that to you guys when we have it up and running. I've gotten a lot of calls from other communities lately, or contacts from other communities lately. Like I've talked to Vallejo, I've talked to Olympia. I believe the Springfield mayor came to talk to Beatrice at an outreach thing. Like there's a whole lot of interest in oversight, and I'm excited to be able to share our model with people. The NACOL conference is this week. Actually, Michael Hames Garcia texted, and I think he's there. So I'm a little jealous, but I did not. September is very full for me, so I did not go to that. But I'm on the communications committee for the national organization, and we've got some interesting things going on with just bringing awareness about the organization, but also about civilian oversight as a whole. And again, I think it's going to be a good way to get our model out to more communities, because I do think at its core, it's very functional. Cancel before January. Oh, sorry. I made a note that I couldn't read. I presented at council in May about the history and structure of our current oversight system. That's recorded if any of you need help getting to sleep at night. But they asked me to come back with recommendations for possible improvements. So the discussion we had tonight around not having eyes on corrective action, that's really helpful for me to have your opinions on that. The discussion around investigating things that even if I can see from the outset that potentially there's an explanation for it, like this is all really helpful for me, regardless. So I'm planning to, I think I'll be going back to council in probably January with those, because we need to finalize a lot of stuff in our office. There's like a convergence happening around October that is intense. So we'll just see how sane we all look next month. Oh, and then we're just the ongoing work we're doing around mediation, just trying to figure out a mediation program that works and results in some changed behavior, trying to figure out a deadly force investigation model that works a little better than what we're doing now, and then early intervention. Those are sort of my three background projects that I'm trying to move to the foreground. So that's my quick and dirty update. I hope that's helpful. My staff are amazing. I'm very grateful for them. You guys, I got to go camping without cell service. It was so good. It was great. Yeah. Of course, the world was on fire, but other than that, everything's fine. So thanks, everybody. Does anyone have any questions?
When the city council asked if you would come back with some things, did you say, I will come back with some things if you hire me?
In the public meeting, did I say that? We'd have to watch it to find out, Bernadette.
Oh, I guess I'll have to go back and watch it then. Okay, that's all.
Uh,
I assume that was.
it's a
not-
fair point. I don't think they'd want recommendations from me if I was no longer auditor. Jose,
Would it be possible to meet at the library next month?
it might be. So the library is actually not set up for hybrid meetings. There's only one room set up at the city, or at least that I know of, that's set up for hybrid meetings, and it's the council work session room. So it's kind of hard to snag it.
Okay.
But we can reach out and do our thing where we try to steal rooms from people and see if it works. I will say, like, I think that's one of the things I'm really most excited about in our new space is having a consistent meeting place where we are every month and not going all around to all the different rooms in the city that might have space for us. So, but yeah, we can check on that.
No pressure. I know your September is a super easy and like low workload month for you. So yeah, it's a low priority thing. Just yeah.
No, it's honestly not, because I think that these discussions are, I think you all adapted very well to doing them on Zoom. I congratulate all of you, but like this mess up with not being able to get Monique in tonight, with not being able to get our minutes recorder in, like, it's just, I'm tired of it, guys. I want it better. I want to see your faces.
All right, with no more questions, we'll do a round of closing comments and we'll just do the same order, but we'll start with Jose this time.
Two things I want to say. Thank you to everybody that shows up and listens to me every week. Appreciate that. And thank you to Lindsay, Rob, and Leah, and Vicky, and Beatrice, Cindy, and everybody at the office. You guys are doing, I will want to say this every single time we meet. You guys are doing an incredible public service. Thank you.
Yeah, I'll echo those things. These investigations are always thorough, and while I disagree with some adjudications from the police bureau, I think the investigation was done well, and there was a lot of information for us to chew on, and you can tell that the city, both the auditor's office and the police bureau, care about investigating complaints, and so that is excellent news. So thanks for that.
My closing comments would just be that it was really great to meet with everyone again. Sometimes, or I think this is the second time I've reviewed cases, it feels really lonely and I don't know what anyone else thinks about anything. So it was really nice to hear other folks' comments.
I don't have anything except to thank everyone, and I always appreciate these conversations, and I like that we don't always agree, and I love that that we can do it in a respectful way, and I think that it helps the process. So thank you all for being here.
I think tonight was a really productive meeting with a really good tone, and I thank everyone for that. I respectfully request that we make a motion that Clay has to pay $1 every time he calls EPD, the Bureau. And then he's up to $5 tonight, but no, that's really affectionate, and I hope you don't mind. And but that's it. And I have one last question for the auditor, and that is, if you can answer, I think, you know, it's a legal question, but if I take the notes that I have and scan them and email them, can I shred the original?
Yes, you may.
I am hearing in the affirmative, and so thank you, everyone. That's it. I appreciate it.
I like how you waited till Lauren was gone.
Yeah, I'm kind of thinking that bureau and department, is that like university and college? It's like department is like a junior, like college, and bureau is
It's
like
Portland. He's
It's just
talking
because-
Portland.
yeah.
Oh, I know he's talking Portland, but that's what I mean. It's like the reason Portland is a bureau as opposed to a department. So they like hit the big leagues and became a
Well,
university as opposed
Our
to.
officers used to be agents. They used to be, that was the name of EPD line officers, was agent. I mean, I think they're all retired now, but so, you know, but anyway.
I didn't know, it's like, can we just like set up a camera, like a computer, and have it on Zoom watching us, and then we could meet at Washington Community Center? Washington Park has a community center. We just set a camera up, or no, that doesn't work.
Well, so one of the things that I was mentioned to me as a solution is a thing, I think they're calling it an owl or something. Anyway, it's a little thing that swivels and it catches everybody. And I'm looking into it.
Okay.
People,
I mean, if
love
it's only
it.
for one, if it's only for 1 month, I mean, don't fall.
It won't be. I mean, honestly, I think that's going to be probably our long-term solution in our new meeting space as well.
Okay.
So I've been waiting, but actually now that I think about it, it's something that could go anywhere. So that's another option that we should look into.
I would just ask everybody to look at the closed cases that were attached to the agenda. And if there's something on the closed cases that catches your fancy, that you think you would want us to review, send a note to Carolyn or Lindsay or Rob or Leah or myself, because we're the ones that like get together and make a decision as to what the cases are. And I think that is meeting like next week sometime, if we can make it. So anyway, so I just, if you see something on that closed case list that you want, just let us know. And I just want to close with the comment that you made, Leah, that said at its core, it's functional. Absolutely. I was here when the last interim auditor was doing some things that made this really hard and less functional. Not keeping things confidential. And that was, a big concern, for the city, and obviously for the auditor's office, and, for us, then the Civilian Review Board. So, I appreciate that we get the updates with regards to public records and ethics, and that we just all remember that, we do the best we can. There's slip ups when we say he or she, instead of just they all the time. I can't remember the last time a name was used, which is far better than it was, when I was first on. But I think, at its core, it is functional. I think we're very, very fortunate that the kinds of cases we have are, while impactful to the people that are involved in them, both, the citizen, making the complaint and the officer, being investigated. It's like in a larger scheme of things in our society, I'm very thankful to live where I do, that we don't have, the shootings and so many other things that we would have to investigate being done by officers. And so I am glad we have our little department and not a bureau. That's all, everyone.
You're glad we have a department and not a bureau, and we have officers and not agents. Jose.
I'm sorry, one more thing. I take my notes on the Stickies app. I don't want to email everybody there.
Vicky,
Vicky, okay, thank you.
sorry, Vicky, but you're the right person.
Okay. With that being said, Bernadette, thanks for asking about input on cases, and I'll add on to that if you have any ideas for trainings. That's another thing that you can suggest. And even if it's something that we've trained before, but it's been a few years and you think it would be helpful to do with this new crew of people, it's not bad to do that.
I should
Like the
mention, well, I've got a training lined up for October. I'm really interested in it. It's in the sort of school to prison pipeline vein, but anyway,
Cool.
sorry.
But you wouldn't mind having a whole list of a whole years of training topics.
I would love a whole list of a whole years. Yes, I'm just excited that I already have one. Like, that's huge.
It's great. Okay, so we will see each other next month. And it sounds like most likely virtual, and we will hear if a solution is reached to meet in person. Okay. Thank you, everybody.
Thanks, everyone.
I'm
Thank
adjourning the
you.
meeting.
Good night.